Hello! Good day everyone, especially to our professor, Attorney Joseph Tomaneng. I am Dinah Shaime Luarez, and for today's video, I'm going to report on the case of Red Line Transportation Company versus Rural Transit Company with GR number 41570 dated September 6, 1934. So before we go over into the facts of the case, let me just bring your attention into these two specific provisions under Act number 1459, known as an act providing for the formation and organization of corporations, defining their powers, fixing the duties of directors and other officers thereof, declaring the rights and liabilities of shareholders and members, prescribing the conditions under which such corporation may transact business, and repealing certain articles of the Code of Commerce and all laws or parts of laws in conflict or inconsistent with this act. So basically, the short title of this act is the Corporation Law. So again, the two specific provisions that I'll be reading to you or that I'll be sharing to you are under Section 11 and Section 13 of the said Act. These are actually provisions that covers the articles of incorporation as well as the power of corporations. So first, let me read to you Section 11. And please take note of the underlined portion of the provision. So I'll just read to you the provision. The Chief of Division of Archives, Patents, Copyrights, and Trademarks of the Executive Bureau, on the filing of the Articles of Incorporation provided by this Act to be filed, shall issue to the incorporators a certificate under the seal of his office, setting forth that such Articles of Incorporation have been duly filed in his office in accordance with law, and thereupon the persons signing the Articles of Incorporation and their associates and successors shall constitute a body politic and corporate under the name stated in the certificate for the term specified in the Articles of Incorporation, not exceeding 50 years unless sooner legally dissolved or unless otherwise provided in this Act. So next, the second highlighted provision in this case is Section 13 of the same Act. So Section 13 basically provides for the general powers of incorporation. But let me just read to you the first power of corporation stipulated under this specific section. It reads that every corporation has the power to, number one, of succession by its corporate name for the period of time limited in the Articles of Incorporation and not exceeding the time prescribed by law. So I just want you to take note on these two specific provisions as I'm going to discuss this further later. So now, let us discuss the facts of the case. So this case is actually a petition for review of an order of the Public Service Commission granting the Rural Transit Company Limited a certificate of public convenience to operate a transportation service between Ilagan in the province of Isabela and Tuguegarao in the province of Cagayan, and additional trips in its existing express service between Manila and Tuguegarao. So, what is this certificate of public convenience? So, certificate of public convenience is actually an authorization issued for the operation of public services for which no franchise, either municipal or legislative, is required by law, such as a common carrier. So, there are actually requirements for the grant of certificate of public convenience. And number one is that the applicant must be a citizen of the Philippines. And if the applicant is a corporation, then 60% of its capital must be owned by Filipinos. Second, the applicant must prove public necessity. And third, the applicant must prove the operation of proposed public service will promote public interest in a proper and suitable manner. And lastly, that the applicant must have sufficient financial capability to undertake proposed services and meeting possibilities incidental to its operation. So these requirements were actually laid down in the case of Kilusang Mayo 1 versus Garcia. So after having been granted the Certificate of Public Convenience to operate a transportation service in the said routes, Rural Transit subsequently filed an application for certification of a new service between Tugigaraw and Ilagan with the Philippine Service Commission, since according to them, the present service is not sufficient. Rural Transit also claimed that it is a holder of a Certificate of Public Convenience to operate a passenger bus service between Manila and Tugigaraw. However, the Red Line Transit Company filed an opposition, and they claimed that they already hold a Certificate of Public Convenience for Tugigaraw and Ilagan, and they are actually rendering adequate service, and that the said application of the Rural Transit would constitute a ruinous competition over the said route. However, despite Red Line's opposition, the PSC, or the Philippine Service Commission, still approved Rural Transit's application with the condition that all the other terms and conditions of the various certificates of public convenience of the herein applicant and herein incorporated are made a part thereof. So because of this, a motion for rehearing and reconsideration was filed by Red Line, since Rural Transit has a pending application before a court for voluntary dissolution of the company. So before the trial, Rural Transit, through its secretary, actually filed a postponement. But at the trial, subsequently, an issue was raised as to who was the real party in interest making the application. Whether it is the Rural Transit, which is as appeared on the face of the application, or the Backrack Motor Company using the name of Rural Transit as a trade name. PSC granted Rural Transit's application for a Certificate of Public Convenience and ordered that a certificate be issued on its name. This decision of the PSC was basically relied on a resolution in case number 23217, authorizing Backrack Motor to continue using Rural Transit's name as its trade name. So let's go now to the issues of the case. So there are actually two closely identical issues here. Number one is whether or not a corporation, such as the Rural Transit, can assume the name of another corporation as a trade name. And can the Philippine Service Commission authorize a corporation to assume the name of another corporation as a trade name? So, as to the ruling of the court, it answered no. So they ruled that they know of no law that empowers the Public Service Commission or any court in this jurisdiction to authorize one corporation to assume the name of another corporation as a trade name. The court further explained that Rural Transit Company Limited and the Backrack Motor Company Incorporated are Philippine corporations, and the very law of their creation and continued existence requires each to adopt and certify a distinctive name. So basically, Rural Transit Company Limited and Backrack Motor Company Incorporated are two different corporations. So just like what I've mentioned earlier about the two specific provisions under our Act number 1459, the court highlighted these portions of sections 11 and 13, which says that the incorporators constitute a body politic and corporate under the name stated in the certificate. So therefore, it is essential to its existence and cannot change its name except in the manner provided by the statute. And further, a corporation has the power of succession by its corporate name under Section 13. So therefore, by that name alone is it authorized to transact business. The law gives a corporation no express or implied authority to assume another name that is unappropriated, still less that of another corporation, which is expressly set apart for it and protected by law. This is so because if any corporation could assume at pleasure as an unregistered trade name the name of another corporation, this practice would result in confusion and, of course, open the door to frauds and evasions and difficulties of administration and supervision. In this case, the order of the Commission authorizing the Backrack Motor Company Incorporated to assume the name of Rural Transit Company likewise Incorporated as its trade name is, of course, void. So accepting the order of December 21, 1932 at its face as granting a certificate of public convenience to the applicant Rural Transit Company Limited, the said order last mentioned is set aside and vacated on the ground that the Rural Transit Company Limited is not the real party in interest and its application was fictitious. So therefore, based on the ruling of the case, a corporation cannot assume another corporation as its trade name. And in this case, therefore, the Rural Transit cannot assume the name of another corporation such as the Backrack Motors Company as a trade name. So that's it. And I hope you've learned from this discussion or from my report. And thank you very much for listening. Bye!